Appearing in the appeals, Royal Mencap Society and Tomlinson-Blake, Shannon and Rampersad.
Yes, good morning.
May it please your lordships and your ladyship, it falls to me initially to introduce everyone, and so this may take a little while. I appear on behalf of the appellant in the Tomlinson-Blake appeal. With me are Mr. Andrew Edge and Mr. Leo Davidson. For the respondent are Mr. David Reed QC, and he has with him Mr. Kieran De Silva and Ms. Georgina Ledbetter. There is, of course, another appeal, the Shannon appeal. The appellant is represented by Mr. Casper Glynn, QC, and he is leading Ms. Cheska Lord. And for the respondent, we have Ms. Judy Stone, and with her, Mr. Christopher Parkin.
Thank you very much indeed. It's right that I should acknowledge that Ms. Judy Stone is appearing, and Mr. Parkin are appearing pro bono. It's far too often that people talk about fat cat lawyers, and they fail to acknowledge that frequently people that do appear pro bono in cases such, very important cases such as this, and it's right that it should be acknowledged. Yes, thank you.
Lord, I'm grateful, and indeed, doubly to her credit is that she and Mr. Parkin have come into this case rather late in the day.
Yes, I noted that, yeah.
May I start by setting out the roadmap, as is traditional? I propose to deal with the matters with your permission in the following way. I'm going to start with a summary of issues and positions, which I hope will crystallise some of the most important issues. I do that partly because, to coin the phrase that Lord Justice Underhill used before, although I don't think there's a positive expectation that someone will be asleep throughout the period of my submissions, past experience suggests that that's a risk worth seeing off. So I'll try and get the important points out during that summary. Then I'm going to move to a short analysis of the facts of our appeal, and the purpose of that is really to allow those facts to be fed into the legal analysis. Then a rather longer section, for which I apologise in advance, on the development of the law, which will be chronological and which will touch on both the low pay commission reports that the parties have identified as being relevant and also various items of guidance which have been issued from time to time by the government, as well as the three different formulations of the regulations with which I'm afraid we're going to have to wrestle. And then concluding the submissions by dealing with the Court of Appeal decision in our case. And insofar as I haven't by that point identified clearly enough the points we say should guide you in relation to the law, I hope that that will be an opportunity finally to tie things together in the context of quite a close analysis of what Lord Justice Underhill had to say below. So putting things into context, you're dealing in this appeal with the question of people who are provided at work with facilities to sleep and who are permitted to use them. Now that particular formulation which I've given you isn't used anywhere in those precise words in any of the three different formulations. So it's intended at a very general level just to encapsulate the various critical factors that define the issue between myself and Mr. Reed in this appeal. And the critical distinction between our positions is this. Our position is, if you are someone who ticks all those boxes, but that you can nevertheless point to facts and circumstances which would persuade an employment tribunal that you were actually performing work within, and in our case, time work, within the meaning of Regulation 3 of the 1999 regulations, or Regulation 30 of the 2015 regulations, you should be able to have the opportunity to do that. You should be able to go to a tribunal and say, let me demonstrate to you that I am doing time work and thus gain access to the minimum wage. That won't be everybody. Our contention, we say, is quite a modest one. It will apply to some people, but not all people. It will depend on the circumstances. And again, what's at stake is access to the minimum wage. The respondent's case is this boiled down. If you are someone who is provided with facilities at work to sleep and you are permitted to do so, you should be precluded from being able to persuade an employment tribunal that you are nevertheless doing time work. In other words, their interpretation of the various sets of regulations are that you are deemed out of entitlement to the national minimum wage, even if you might otherwise be able to persuade a tribunal that you were entitled to it. We say there's no obvious policy which calls for that result. In fact, one would have thought the policy underlying the National Minimum Wage Act would point in the opposite direction. Such policy as is identified by the respondent in the course of their submissions is that it provides a greater certainty for employers, and we said that might be right, but it can't be that policy dictates certainty at the cost of poverty. And we say that's the risk here. The risk is that their approach potentially creates, particularly in relation to people who are working permanent sleep-in shifts or working permanently as night watchmen, we'll come to the Scottbridge case in due course, they are created as a class of worker who have no access to the national minimum wage unless they are performing specific tasks during the course of their shift. They are people who will get less than the national minimum wage for the shift periods that they work. And it really goes without saying, one would have thought, but the minimum wage itself is already not a path to riches. It's set deliberately at a minimum level. It is set at a level which is below what is acknowledged in other circumstances as being a living wage. So that's what we say the crystallisation of the dispute is. We think you should have a chance of persuading an employment tribunal, as the claimant did in this case, that she was working. The respondents say you should not have that opportunity. So how does that resolve itself into questions for your determination? There are really 3 points I want to raise at this stage. The first is, what is the question? And the question is, in the circumstances of the kind we have described, are people working or are they to be treated as merely available for work? The second point for consideration is, how should that question be approached in terms of its determination? And you'll have seen, no doubt, from the written submissions that there are really 2 aspects to that. The first is our position that as a matter of both logic and statutory interpretation, you do that in what we've called a sequential manner. You ask first whether someone is doing work, and if not, are they available for work? If they're available for work, is there otherwise a ground for exempting them from entitlement?
Is there a clear dichotomy between the two, I wonder? I mean, working and available for work. And all types of employment that one can envisage where you're not actually doing anything, but you're at work, so to speak.
Well, taking that head on, we agree with what Milady Arden had to say in Walton, which is that there is a clear dichotomy. Certainly as far as the regs are concerned, the regulations seem to assume that there's a clear dichotomy. Having spent a long time as an employment lawyer, if what you put to me is, are there circumstances where it may be difficult to tell in a particular case on which side of the line you fall, the answer is yes. So this is one of a number of yardsticks or tests which are applied in employment law, which aren't always immediately amenable to a very clear answer. And that's part of, as it were, the cultural difference between myself and Mr. Reid. He says, whatever happens in other aspects of employment law, and indeed whatever happens in other aspects of the application of these regulations, this must be a bright line test and we're going to make it one regardless of the results. So what I'm going to propose to you, and I hope this will help you, and this will happen in about 30 seconds' time, is a classification of jobs which we say will illuminate that difficulty and hopefully provide you with some guidance. So just to pick up the thread, how do you approach the question? We say sequentially. If you do it on that basis, what kind of question is it then? We say that it's essentially a question of fact, because it's a question of fact, it lends itself to what we've called a multifactorial analysis, which is just really a fancy pants way of saying that if you're determining a question of fact, you take into account all relevant evidence and all factual evidence before you. To pick up immediately on a point that I made a few moments ago in the context of answering your question, my lord, when one looks at the regulations and the Act, what one finds is that there are a lot of questions of this type which need to be considered before an entitlement to the national minimum wage can be determined. So for a start, if I could invite you to take up the first authorities bundle. And we're at tab 1. My authorities bundle only has MS references in it. I don't know if that's also true of the bundles in front of your lordships and your ladyship. But if one turns to the National Minimum Wage Act and section 1, you'll see it's headed workers to be paid at least the national minimum wage. It says, subsection 1, a person who qualifies for the...
Can you give us the MS?
Sorry, it's 5, MS5.
5. Yes.
A person who qualifies for the national minimum wage shall be remunerated by his employer in respect of his work in any pay reference period at a rate which is not less than the national minimum wage. And at 2 it says, a person qualifies for the national minimum wage if he is an individual who is a worker. Now, I know this court and many others below have wrestled over decades with how you delineate who is and is not an employee, who is and who is not a worker. And the approach which has been taken traditionally is to say that one has to look at all relevant factors in making that determination. So the very starting point for entitlement, your worker status, is already one which is a multifactorial question, and which no employment lawyer with a straight face would say is amenable to a bright line definition. You will see, I hope, if you've not already seen, that when one comes to look at the national minimum wage regulations, they divide work into various different types. So our appeal is concerned with what is known as time work. My learned friend Mr. Glynn's case is concerned with what is known as salaried hours work. And when we come to look at the Walton case, that was concerned with a still different kind of work, work known as unmeasured work. So one of the issues that the tribunal has to decide is into which category of work does a particular case fall. And if I can invite you, still within the same bundle, to turn to tab 10 and to MS page 163, where we're in the Walton case. I'll come to the facts of Walton in due course. We don't need them for present purposes. If one looks at paragraph 31 at 163, you'll see it says Regulation 3A is concerned with work that is paid for. In this case, it is the work carried out by Ms. Walton, caring for Miss Jones. Upon the assumption that I'm making it takes place over a period of 24 hours, is the payment to her by reference to the time that she works, or is it by reference to other matters? So that's the sort of question I've just identified. This Court of Appeal is asking itself, is this a time work case, or is this an unmeasured work kind of case? And what Lord Justice Alders says, and we gratefully adopt, is this answer must depend on the facts. So this is another question for determination within the scope of the national minimum wage regs, which depends on the facts. And a factual determination of that kind is going to require any court or tribunal to consider all relevant factual evidence. So we say there's nothing special about these regulations. They don't call for a different approach to the determination of questions of fact one might find in relation to any other issue or any other piece of legislation. If it's a factual question, the appropriate course is to ask oneself what the evidence says and where it leads. And that brings me to the proposed classification, which I teased you with a few moments ago, which I hope might help illuminate the boundary between availability for work and when one is, to use the phrase which is used in some of the EET authorities, working by being present. So what I'd ask you to envisage is effectively a spectrum of different sorts of jobs. At one end of the spectrum is a job which has a high frequency of specific tasks for performance. So to pull an example out of the air, if you imagine someone who's working on an assembly line, stuff is coming at them pretty much non-stop. You know, their hands are moving, their brain is engaged, they are constantly having to perform specific tasks. But at the other end of that spectrum are jobs which have a very low frequency of specific tasks. So to take what I hope is not the most ludicrous example yet put to the Supreme Court, if you imagine the people whose job it is to have a finger on the nuclear button, they hope they never have to press that button, that the core element of their job never arises. So it doesn't get any lower as a frequency than that, but north of that, there are obviously jobs like the one we say the claimant does in this case, or like the night watchman in Scottbridge, where a good night, a good shift will be one in which they don't have to perform any specific task, but their job in those circumstances is to be there, to identify when a task arises, and to be the person who is responsible for dealing with it. And that, we say, well, when you look at the authorities, when I take you to the authorities, is if never made quite explicit what is really going on in the minds of the judicial decision makers, that there are some people who are not accurately described as being on call for the performance of some other job. Their actual job is to be present, to determine when their intervention is required, and then to intervene. Now that twofold classification, or to that twofold classification, I add an additional element, which is what I'm going to call being merely available to work. So just to take what I hope is a non-controversial example, if you start with a high-frequency case, it might be, for instance, that you're working in a factory and the factory's policy is to have sat in a ready room or perhaps bunked down on a mattress additional staff just in case, say, a machine breaks down and they have to make up for lost production, or there's a sudden increase in demand which requires them to call on people to step in. Now, those people are assembly line workers, machine operators, who in those circumstances are genuinely on call. They are waiting to do, as it were, their real job, but they'll only be called on to do it if it's necessary to call on them to do it. So you can have a job with a high frequency of specific tasks, and you can be on call for that job. You can be available for it. But the same is true, importantly, of a low frequency task job. So you think, because this is an example that is foremost in the mind of Lord Justice Underhill, for instance, you might have someone who's not in a private home, but in a large residential home. And you may have someone whose job, modelled on my client's job, is to be the person principally responsible over the course of a night shift for ensuring that if anything happens, they react to it and they call down the necessary resources to deal with it. And they may be someone elsewhere, sleeping in a room, who is genuinely there on call, who may be called on to perform that task. But that's, we say, not simply a meaningful distinction, but one which is consistently, if not always overtly, recognised by the authorities in this area. So that's
also one way of looking at it is, if you're removed from your personal autonomy, from doing whatever it is you want to do, and there is a restriction on that to the extent that you have to be available should you be called upon, then arguably that does emphasise the distinction between the two.
My Lord, I think that's right. And it will become, I hope, clearer, or perhaps I should say sharper, as a distinction when we come to look at the particular facts of this case. Because without wanting to, as it were, spoil the surprise, what we're going to be saying about that is, this is a case in which a local authority and Mencap had their own specific duty. And their work was to make sure that there was someone available to do precisely what our client was doing in this case, which was to be there throughout the night, to have specifically responsibility for the welfare and safety of two vulnerable adults. That's the work they needed doing. That's the work she was doing. They don't want to pay for that work by reference to the national minimum wage. And we say the tribunal was right to find that they should do. So that classification is one of two overarching points which I'd ask you to bear in mind as we go forward. The second is this, and it involves a degree of reiteration, for which apologies. We're not suggesting that always and in every case, someone who is provided with facilities to sleep at a place of work and is permitted to sleep must be treated as working for the purposes of either Reg 3 of the 1999 regs or Reg 30 of the 2015 regulations. But more importantly than that, we say when one comes to look at the Low Pay Commission recommendations and some of the guidance, we say they are resolutely focused on that second kind of case, the kind of case where you are provided with facilities at a place of work and permitted to sleep and couldn't persuade a tribunal that you were actually performing work for the purposes of Reg 3 or Reg 30. In other words, that properly understood, the Low Pay Commission reports don't really touch on our facts. They're concerned with what they think is the more usual set of circumstances in which you couldn't make out a case for actual working. And I'm afraid you hear me repeat that from time to time. I'll try and keep it to a minimum. But that's our overarching point in relation to the Low Pay Commission recommendations. Can I make one last point in relation to classification and the nature of jobs, which is this? There's a tendency in some of the authorities, and we say, no disrespect intended in some of the submissions being made on behalf of the respondents in this case, to think about tasks as if they're always physical. So they're always getting up and doing something. And that is to downplay the significance of monitoring whether anything needs to be done, of exercising judgment in those circumstances, deciding whether or not this is a moment in which someone should intervene. And then finally, in this opening summary, and again, because it's not clear that this is acknowledged in the submissions made on behalf of the respondents, no authority, so far as we are concerned, has ever gone so far to say that if you fall into Regulation 3 or Regulation 30, in other words, if you have persuaded a tribunal, or could persuade a tribunal that you're doing what my learned friend calls actual work, that time spent asleep cannot count for the purposes of time work. In fact, what we'll see is the position is the opposite, and even in the Court of Appeal in this case, there's an acknowledgement that it can. So time spent between performing infrequent tasks can be time spent asleep, as we'll see on the authority of the BNA case, and still count as work. So with that, I complete the first section. We're through to walking through the facts, as it were. It might be helpful to have open Appendix 2A, which is where you'll find the tribunal's decision. And it starts at page 79, which is MS page 629.
Sorry, say that again, please.
MS page 629.
629.
Or page 79 of the physical bundle. So I can take you hopefully the background facts relatively straightforwardly. The starting point, the focus of this all, although often forgotten understandably in the circumstances, are two vulnerable adults. They're ultimately the recipients of the services. They're people who are living in private accommodation, and they need care 24 hours a day. Now, it's right, as we'll see, that when they're asleep, the frequency with which specific, as it were, physical or hard caring tasks might arise would decrease. But we say what one might call the soft tasks, so keeping a listening ear, exercising judgment, etc., they continue to be required to be performed throughout the whole 24-hour period. The provision of that care was the responsibility in the first instance of the local authority, and the parties are agreed, as I understand it, that that was a statutory responsibility imposed on the local authority, and that it arises under the Health and Social Care Act 2008, Regulated Activities Regulations 2014, and we have that in the authorities bundle at tab 5, MS 83, but I'm not proposing to take you there because as far as I can tell, it's not a disputed issue. The local authority carried out what was called a care and needs assessment to create a care and support plan. What they then did, because they needed someone to deliver that care and support, was contract with the respondent in this case, Mencap, and they were to provide care in accordance with that plan. So, pausing there, providing that 24-hour care was, as it were, the work that was required of Mencap under its contract with the local authority. It was the service that Mencap was intended to provide. Just to make that good, although you may think it's obvious, if I can invite you to turn to page 6, MS 631, or page 81 of the judgment, and to paragraph 10, you'll see the second sentence, it says, in the event of any emergency, the respondents do have a call-in service available, but it's absolutely clear that there is an obligation upon Mencap to ensure that throughout the period of that sleep-in shift, there is someone at the house qualified and able to provide such care to the service users as might be required. So Mencap's job, as it were, Mencap's service is to make sure there is someone there, that person is suitably qualified, and if they're required to do work, that they're in a position to do it. Now, of course, in order to provide that service, Mencap needs care workers, and our client was one of those. So when the care worker sets off to start their sleep-in shift, as they've been consistently referred to, what they're doing is they're going to their place of work to do the work that Mencap has undertaken will be done.
Well, you're calling it work, but that may be a little bit contentious. It may simply be a service, which may or may not involve work.
Well, all services, it's difficult, we say, to deliver a service without someone doing some work.
Or, yes, indeed, but not full-time work.
No, that's true. And what is being provided here, the service that is being provided, and thus the work that is required of the individual, is to be there. You have to be a qualified individual, is to be there and to respond. So, well, I take your point.
Yes, I suppose it depends on the connotation that one places on work. I mean, traditionally, I suppose, or conventionally, one would regard work as actually doing something actively. But you might want to argue that work is being available to provide a service when called upon.
Well, that's exactly what we're contending. So to just nudge back to the classification, we say there are some jobs where the expected frequency of task is so low that really the most sensible way of describing that job is that you're to be there to perform tasks occasionally, as and when they arise. And that's the nature of the job. It's not being on call to do a different job.
That's
That
not
is the
work
job.
then, is it?
Sorry?
Do you say that that is not work?
We say that is work.
Oh, yeah.
And that's what that is the specific work and job that the claimant was doing in this case, and which, as we'll see, the tribunal concludes is work for the purposes of Regulation 30. So, yes, very much our case that that's how it operates.
So we need a contemporaneous understanding of the expression work.
Yes, and the regs don't help you because there's no specific definition of what work means in the regulations. So we'll come to that. But the tribunal in this case and in a range of EAT authorities, as we'll see, have decided that you can be treated as working for the purposes of Regulation 3 or Regulation 30 in certain circumstances by being present, if that's what in effect, the essence of your job is. If you're performing this kind of work. It won't arise in every case, but if the facts point in that direction, it's open to a tribunal to conclude it. And what you'll see is there are various, as it were, ancillary factors which point in that direction. And one of those arises in this case, which is if your employer has an obligation to make sure someone is present, that's the service that they're providing. They can't do that. They're a non-physical entity. They have to get someone to do that, to be there to ensure the service is provided. And that's the job. So there are, in the case of this claimant, she worked both day shifts and sleep-in shifts. So the day shifts are more obviously what people would immediately recognise as being work. So far as the sleep-in shifts are concerned, what one has to bear in mind is that there are some people who only do those, just work sleep-in shifts. Just as we'll see when we come to Scottbridge, there are some people who only do a night watchman role, where they dearly hope that for the whole of, or that for most of their evening working as a night watchman, nothing will happen that will require their intervention.
So in effect, what you're arguing is that if an individual fulfills the requirement of the service which the particular society or agency is required to provide, then that qualifies as work.
That can qualify as work. So because
In what circumstances does it not qualify as work?
Well, I think it almost always should. But what I'm here arguing for is a multifactorial test in which no single factor is determinative. So what I say to you is, yes, that will always be the determinative factor, I'm actually arguing against myself. So I'm discouraging myself from taking that course. But I have to be live to the possibility, as Lord Justice Underhill accepts in the course of the consideration of this case below, that there are sets of circumstances which might differ from time to time subtly but nevertheless materially, and that tribunals might reasonably reach different decisions in relation to cases which are on the face of them similar. I think this factor, that you are fulfilling a particular, you're allowing your employer to fulfill a particular statutory duty, is one which is of specific significance and weight. And when we come to look at the EAT authorities, albeit at something of a canter, what you'll see is that that factor has been identified in the authorities in the EAT as being one which is of particular significance or likely to be of particular significance.
Can you define the factor? I'll just write it down.
It's where your employer, the person engaging you, has in effect to have you present performing these duties in order to fulfill a duty of its own.
For performing the employer's duty.
Yes.
Well, that's why I have a slight difficulty in understanding the circumstances in which, although you are performing not fulfilling the requirement of the employer, that you might not be working.
I understand. And without...
You must help us more on that, Mr. Jones, before the end of the case. You really must, so we can wrestle with
Well, there's a
the
sense...
distinction that you're making. And it isn't helpful enough just to say, well, it's all a question of fact. Almost always yes, occasionally no. You must bring it to life if you possibly can.
I'll endeavour to do that now. Could I invite you to take up...
Sorry, just before you do, could you help me with this? I mean, one could fulfil a service or meet a statutory obligation by working intermittently. One doesn't have to be working full-time.
No.
One can't simply jump from the fact that one's obliged to provide a service or is subject to a statutory duty, which is a continuing duty, that necessarily entails somebody working full-time.
Well, let me be clear what we're saying about this. And work through it in stages. Firstly, of course, the duty itself may be only intermittently to provide the service. So in that case, of course. So far as the service in this case is concerned, the service that is being provided is ensuring there is someone there 24 hours a day.
There's someone available.
Someone who is not simply available, but someone who is responsible throughout that period for the safety and care of those individuals, and whose job it is to make sure that if anything which arises in relation to it, that they respond.
But the actual paragraph you read us is neutral as to whether that's to be a person who is working or who is available to work.
I'm not now quite sure which paragraph you have.
Paragraph 10 of the Employment Tribunal. You didn't take us to regulations.
Yeah, I haven't yet come to their determination in which they make it clear what their position is, because I'm happy to do that now, or I'm happy to accept, as it were, the invitation to help a little further with the question of the relevance of regulatory requirements. I don't really mind which order I
thought the question was broader, namely there has to be some kind of certainty attached to help us delineate the category of worker.
But let me be honest, I mean, category of worker is one very helpful phrase to fix upon. There's going to be a limit to how certain this will ever be in circumstances where you have to take into account all the circumstances of the case. There are going to be some factors which are more important than others, and those factors have been identified in a series of authorities, most of which have now been overruled by Lord Justice Underhill below, and which I'm going to invite you, as it were, to restore by overturning his decision. There, in my submissions, there's a summary of those principles. Two cases, South Manchester Abbeyfield Society in Hopkins, and another one, Anderson and Jarvis Hotels, being distinguished by a case called Esperon, are ones in which the existence of a regulatory requirement to have someone present is identified as, to use the words in Esperon, a powerful indicator that you're dealing with someone who is working by being present. So that's the phrase which is used by the Employment Appeal Tribunal in Esperon. Now, I agree, it's a very powerful indicator, perhaps, and I take my Lord Carr's point that it may be difficult to envisage circumstances in which it's not so powerful an indicator that it's going to take the case home. But a powerful indicator is ultimately still an indicator.
Well, my Lord Wilson, I think, has put his finger on the problem here. We have to try to identify what the principle is. It seems to me that your argument amounts to the proposition that if there is a restriction on the autonomy or the behaviour of an individual by being present, that that is, at the very least, a powerful indicator that that individual is working. But
Yes.
it may be that you aren't prepared to go quite that far, in which case, as my Lord has said, we really need to know what the contours of your submission are on this question.
Well, let me try and be as clear as I can on that then. My case is that the mere fact you are subject to a restriction, qua employee or qua worker, that you're required to be in a particular place by your employer is not sufficient. And the reason why I can be blunt about that is because I accept that there are some circumstances where applying Regulation 32, you will be treated as not even available for work because you are at the place of work by requirement, because that's what the regulations say. So your employer insists that you're there, you're provided with sleeping facilities and you're permitted to use them. So the mere fact that you're required to be in a particular place is not enough. When one looks at the EAT cases, insofar as they touch upon this requirement, there are two different factors which they bring to play. And they are, might be simpler if I invite you to have a look at my written submission where I touch on these. So, ask your indulgence for a moment.
Well, do you say that if you're required to be in a particular place and you're required to respond to a request to perform a service, that that is sufficient?
It may be. Sorry to... I'm desperately trying to be as certain for you as I can be, and I hope to be a little more certain than I'm probably presently appearing to be. But if I can ask you to turn to the submission, the written case,
Which
in the
page,
core
please?
volume. So it's MS page 483.
483.
There are two related, what one might call, presence factors that have been identified.
Paragraph 18, is it?
It's paragraph 18. So if one starts with the second one, the employer is required to remain on the premises throughout the shift and would be disciplined if they slipped out. That's then President Mr. Langstaff's formulation in Whittlestone, where specific hours at a particular place are required on the pain of discipline if they're not spent at that place, and the worker is at the disposal of the employer during that period, it will normally constitute time work. So that's the AT saying, so far as presence is concerned, if it's not simply the employer saying, come here and be on call, but you're subject, as it were, to a discipline-back requirement to be present, that is a factor which points towards time work. The point I was developing is the one above that, in subparagraph 1, where you're not focusing, as it were, on the employer having told the employee that they must be there, but you're focusing on what the employer's obligations are. And if the employer has an obligation, in that case and in this, in a regulatory requirement to have someone present, to be responsible for care and welfare, in this case, to be the person who has to decide whether or not something needs to be done, and have their ears listening to see whether that arises, that is, quotes from Esperon, a powerful indicator that one is doing work for the purposes of then Regulation 3, now Regulation 30. So those are two related but distinct, one might call requirement to be present factors. The one that focuses on the relationship between the employer and the worker, that's 2, and the one which focuses on the employer's own obligation in terms of the service they're providing, that's 1.
Well, I can see that they're related, but I'm not sure that they're distinct. But I mean, just to revert to my Lord's very pertinent point, the question is, where does the powerful indicator fall down? And if you're an employee who is required, because of the terms on which your employer is engaged to provide the service, to be present, in what circumstances are you not working?
Well, let me take 2 examples which I hope might meet that point, although whether they have arisen or will arise is another matter entirely. If one thinks about the relationship between these 2 factors, so just focusing on those for now. What if the employer has a regulatory requirement to have someone present, but says doesn't have to be you all the time. If you want to slip out and see a movie or get chips, which are the 2 examples that we used in the Wilson case itself, give us a call and we'll send someone else, and they'll cover for that period. So that it's not your job in those circumstances to be present throughout that period and ensuring that there is ensuring that there is cover. Another factor which arises in the EAT...
But that contemplates that there's going to be a substitute for you while you go to the cinema or go to buy chips.
Yes, and arguably a substitute for them ad infinitum, but they are not as an employee, they're not as a worker. The person who, as it were, is responsible for making sure that they are there the entire time. So another example which is given in...
Yes, but I mean, just to take that example, I mean, surely on your analysis, the person who substitutes is working.
They may be, we don't know what instructions that they are given. So I feel this awkwardness, I'm desperate to agree with you. I'd love it if you were to say, in 100% of the cases in which someone is present fulfilling a statutory duty of the employer or a regulatory duty of the employer, that will be enough. My difficulty with that is that I do think goes further than I can sensibly argue. But I agree with you, and I am in fact presently demonstrating that it is phenomenally difficult to think of circumstances where that wouldn't be the case. So I'm not deliberately failing to come up with sensible examples. I think you're right that they would be very rare. So that for the most part, and in most circumstances, that powerful indicator would get you home. So I might be tempted to steal the language from Whittleston quoted in the second bullet point. Perhaps I could say it will normally constitute time work. But what I was moving to say is, in the EAT, in this case, what then President Simler does is set out, as it were, a précis of the various different factors and guidance of the sort that I've attempted to do here. And one of the things that she says may be relevant is how immediate a response is expected of you as the person who is present, what specifically is you are required to do. So she seems to suggest, for instance, that if all you're required to do is phone the emergency services, that might be less indicative of you performing time work than if it is your responsibility to get up and deal with matters. Now, those are going to depend on particular circumstances of a case, but again, I agree that in circumstances where your employer has to have someone there, it's a matter of regulatory responsibility, providing, and that you are the person providing on their behalf the very service that they have contracted for, it's just unrealistic to think of that as you being, in some sense, on call. That is the job, and that's the job that you are performing. That's the work that you're performing. May I take you back to the finding in this case? We'll see how the tribunal dealt with it. So that is in Appendix 2A. And if I can invite you please to look at paragraph 34 of the tribunal's decision under the heading Findings, which is at MS 637. What they're doing here is, we say, recognising that distinction in classification that I adverted to earlier, that there are some jobs, some work, which takes the form of low frequency of requirement for specific tasks. And you'll see it says here, it's my conclusion that Ms. Lorraine's submissions are to be preferred. With respect to Mr. De Silva, the fact that the objective in providing support to the service users was to maximise their independence is not to the point. What matters is what needed to be done to achieve that objective. As those authorities to which I've already referred make clear, the fact that she may be called upon to carry out actual work infrequently is not to the point. So they're saying this is a case where you're dealing with precisely the sort of classification that we identified earlier, which is that some jobs, low frequency of requirement for specific tasks. And then if I can invite you to turn over the page to MS 638, you'll see the number their conclusion of paragraph 40. So we do not think that Mr. De Silva fairly describes her function as being on call. This was not a situation, they say, like Shannon. I say that conscious that Shannon's an appeal in front of you before as well. Being on call suggests that you can be where you want and be doing whatever you want, provided that someone can contact you when your services are required, and that you ensure that you are capable of responding to such a request. Such a situation is far removed from the claimant's obligations whilst performing a sleep-in shift. She had to be there. She would have been disciplined had she not been there, so that's the second of the 2 points we looked at earlier. The respondents would have been in breach of their legal obligations if she'd not been there. More importantly to me, and this is getting to the nub, is the fact that whilst performing that sleep-in shift, the onus was constantly upon her to use her professional judgment and to use the detailed knowledge that she had of the needs of these residents to decide when she should intervene in order to meet their needs, and when she should not, in order to respect their right to privacy and autonomy. This epitomises her role as carer, which it seems to me she was performing either during a daytime shift or keeping a listening ear in whilst in bed, asleep or not. So their approach, and as we'll see, that arises from a long and now well-established line of authority, is to say there are some jobs, low-frequency task jobs, where the essence of what you're doing, in this case being a carer, continues whether or not you are doing something specific, because you have that ongoing
one can
responsibility.
quite see the distinction between, on the one hand, being required to be present at a particular location and to respond to every call upon your service, and on the other, an ad hoc system whereby you can be asked when the need arises, and especially, I suppose, if you are at liberty to decline to answer the call. I mean, those are two quite different situations. I mean, the latter case, I think I can discern a fairly strong, not to say powerful case, that is not working. But if you are required to be present at a particular location and you are also required to respond to the call, not at your option, but you have to do it, I can't see how, on the basis of your current argument, how that can be less than work.
Well, I'm delighted to hear that.
No, well, I mean, this is very much a tentative, not to say...
even tentative, it's more welcome than the opposite.
Yeah.
So I'm grateful for that.
But I mean, if you feel that it is not the right conception, well, now's the time to articulate what you believe to be the proper approach.
No, I do feel it's the right conception. It arises from the more detailed guidance and consideration that the EAT has gone through over the course of more than a decade, and which has been applied reasonably consistently since. All I'm really seeking to do in doing anything other than immediately, as it were, jumping the bench and accepting your analysis is just to say that although I can't immediately conceive of a wide range of circumstances in which that would not be enough, I have to accept that there may be circumstances in which that will not be enough, because ultimately it's a question of fact assessment.
Yeah.
I mean, that paragraph 40, the finding of fact, you say, has that been challenged as a finding of fact?
No, and that's the really, yes and no. No, it hasn't been challenged on the basis that I don't understand Mr. Reed's case to be that this is in any sense a perverse finding.
Yeah.
It seems to be accepted that if the tribunal, if it's open to the tribunal to find that our client was working for the purposes of Regulation 30, then this is a sound conclusion. In the Learned Friends case is it's not open to the tribunal ever to reach this conclusion, that they are, as I described at the outset, precluded from determining that in circumstances where there's a place of work, a bed and permission to sleep, that you could ever be allowed to persuade a tribunal that you were working.
Oh, well, how he puts it. But I mean, on that basis, remind me, how often did she in fact exercise a professional judgment, decide she had to intervene?
Well, we don't know. What we do know is that she had, if I remember rightly, in fact intervened on about 6 occasions in the previous 16 weeks. How often she exercised her judgment? Sorry, how often she had...
6 occasions in 6 occasions in?
16 months. Yeah.
16 months.
6 occasions.
It's rather different.
So what we don't know, of course, is how often she exercised her judgment or was called on to exercise her judgment.
But it's a slightly odd concept. She's sleeping there. You say that she sort of decided, well, maybe I should intervene, maybe I shouldn't. Maybe I'll stay asleep. I mean, but in fact, only 6 times in 16 months does she actually get up and do something.
Well,
that must be a factor too, the frequency, mustn't it?
It is. So that is something which is identified, albeit that there will be jobs, as I described at the outset, where your dear hope is that you never have actually to intervene, but it's nevertheless your job to be present to do so if you have to.
May I ask this? Is it possible that work is one of those terms which takes its meaning from its context? It may be used differently by different people in different circumstances. And so one has to really look at the context here, which is the regulations themselves.
Yes.
Decide what work means in this context.
Well, that's true, and undoubtedly true. The regulations don't help you with a specific definition. I'm not sure whether this is agreed or not, but certainly on the face of the authorities taking the sleep point, it seems to be accepted that if you are in a case where you're not provided with facilities to sleep at a workplace and given permission to sleep, but nevertheless do sleep between the performance of infrequent tasks, that can count as work for the purposes of Regulation 3 or Regulation 30. And there's, even in this case, below, Lord Justice Underhill says, well, that's clearly established by B&A nursing. That's not in dispute. So whilst it might seem odd that sleep can count as work, there doesn't seem to be any dispute that sleep can count as work for the purposes of Regulation 3 and Regulation 30.
I wonder whether that's the right way of putting it. It's availability that counts as work rather than sleep. I mean, the fact that you can sleep during the period that you're required to be available, in one sense, is perhaps incidental to the issue.
Well, I need to be careful with the language there for this reason. That what the regulations do is draw a distinction between work and availability for work.
Right.
And the key to understanding the B&A and Scottbridge decisions is that in those low-frequency task cases, the gaps between the tasks are not treated as ones where you, as it were, move from the working column to the availability to work column and then back to the working column in circumstances where a specific task arises. You're treated throughout that period as working, whether you're performing a specific task or not. And to come back to Lord Kitchen's point, just I hope to complete it, the genius, as it were, of the way in which this question ultimately gets formulated by the EAT in the Hopkins case is they say, well, the sensible way of looking at it is that there are some cases where you are working by being present. And there are other cases where you can't establish that you are working merely by being present. So once you accept that as your test, it may be relevant to consider how frequently you're called upon to perform a specific task. But it's only a factor, because the real question is your presence and responsibility and your obligation to rise to a task when it arises your job, rather than your job being an accumulation of specific tasks that you perform. So that's, as it were, the distinction which has been drawn in the authorities. It's the one I invite you to adopt on the basis of the authorities to date, barring the Court of Appeal. In this case, are you working by being present? And we say one set of circumstances in which we say almost certainly you are, circumstances in which your employer has an obligation to make sure you are present because that matches their own regulatory responsibility. So I sort of promised myself I wouldn't mention Milton, and they also serve who only stand and wait, not least because I made a fool of myself below by saying there are some people whose job it is just to wait. We could call them, say, waiters, and then as soon as I'd said that, I realised it was a absolutely absurd name, and it was already taken for a different job. But that's the essence of it, that there are some people whose job it is to be the resource in place, suitably skilled to meet the tasks as they arise, and capable of deploying themselves. So it's not, as it were, a kind of classic on-call case where you're on the end of a phone waiting for someone to tell you it's time to work. You're the person who decides whether or not there's work to be done. And in a case where you have to be there because your employer needs someone to be there to meet a regulatory responsibility, we say all the clearer, and save but in very outrageous circumstances, that should be enough to get you home, and was enough to get the claimant home in this case on a finding of fact that no one is suggesting is perverse if it was legally open to the tribunal to ask it.
Yes.
So with that, can I take you to the law? I appreciate we've done some of it already, but can we start, please, in Authorities Bundle 1 and Tab 1 with the National Minimum Wage Act, 1998. So it is Section 1, which, as it were, creates the underlying right to the national minimum wage. To qualify under subsection 1(2), you have to be a worker. Identified, I hope, already that that is traditionally a question that you approach on a so-called multifactorial basis. But because we're going to be looking at purposive constructions going forward, it's worth just making the really obvious point that the purposes of this legislation is to create an entitlement to a minimum wage, which can be relied upon by those who would otherwise be the worst paid workers in the country. And there's a sense in which if you qualify for the minimum wage, you remain the worst paid workers in the country. But this was an entitlement that the market itself was not producing. So there was seen to be a mischief, which is underpayment of people in particular kinds of work. The National Minimum Wage Act was intended to make sure that reasonably consistent underpayment was done away with. Now, why does that matter? It matters because, as I've already said, it seems to us that one of the consequences of my learned friend's analysis is that there will be some people, night watchmen, because he says Scottbridge is wrong, permanent sleepers in, who are deemed out of this entitlement And it would be a very odd conclusion, we say, if the appropriate and purposive reading of national minimum wage regulations and the National Minimum Wage Act is to create classes of workers who are not disentitled from receiving it. So one should be slow to reach the conclusion that that's what was intended.
I just interrupt that. But,
Yes.
but as I understand it, that's not what's said. What is said is that people are working for only the periods that they are intervening, and they of course accept that there should be a minimum wage in respect of those interventions.
Certainly. So if you are, for instance, a night watchman, you let yourself in, take a turn around the office, go to sleep, wake up, hand over to the day shift.
Yeah.
Month after month passes in which you're not required to phone the police, wrestle a burglar, put out a fire. So far as my learned friend is concerned, at best what you're doing is the 10-15 minutes of the initial walk around the office. The overwhelming majority of what you, of the way you spend your working life, none of that counts. Now there may be, and this is a critical factor, what is said is there's an expectation, and indeed to some extent a past practice, that your employer will pay you some sort of allowance. But the allowance, firstly, by definition, is likely to be less than the national minimum wage, otherwise there wouldn't be a dispute. But nothing in the Act or the regulation requires that allowance. And as we'll see, what happened as a result of the introduction of the exemption, or the exception that my learned friend relies upon, is there were a swathe of care workers who had their allowances taken away because there was nothing in the statute which required them to be paid one. So we'll see that when we come to the LPC second report. So, my lord, you're right. It may be that even in that sort of case, what you've got is a worker who may, on occasion, receive something by way of remuneration by reference to the national minimum wage. But the overwhelming majority of what they do is not something which generates a national minimum wage entitlement. So, pressing on in the Act, so far as Section 2 is concerned, this is the power conferred at subsection 1 on the Secretary of State to make regulations, making provision for determining what is the hourly rate at which a person is to be regarded as working for the purposes of this Act. There are several other matters in relation to which they can make regulations, and at 2 subsection 3, the regulations may make provision with respect to A, circumstances in which, times at which, or the time for which a person is to be treated as or as not working, and the extent to which a person is to be so treated. So the regulations can provide a definition of work and identify the circumstances in which it counts. And pausing there, one thing to note is the government could, therefore, from day one, have included a more detailed definition of work, or indeed any definition of work. And they could, from day one, have said, for instance, if they found the notion of working while sleeping impossible to contemplate, simply have said that sleep will never constitute. If you're asleep, you're not working for the purposes of these regulations. And as we'll see, they don't do that. Section 2.8 is important. That's over the page at MS page 8. There is a limit on what the regulations may provide for. And one of the limits is that they can't make provision which treats the same circumstances differently in relation to, you see at 8B, different sectors of employment. So you can't have a special set of care rules. You have to formulate a principle which applies to materially identical circumstances across all sectors. And then in section 5, what we'll see is that there's before the first regulations are issued, there's an obligation to make a reference to the Low Pay Commission, which the Act also establishes, or provides for the establishment of, I should say, the Act. Certain questions at 5.2 have to be referred to them. None of them say in terms the periods or the hours for which someone is to be remunerated, but we accept that it was appropriate to ask the Low Pay Commission to consider the issues they in fact considered, appropriate for them to make the recommendations they in fact make. At 5.3, the Low Pay Commission has to make a report which it does. And at 5.4, the Secretary of State then has the option either to implement the recommendations or else prepare a report saying why they're not doing so. And we accept that the Low Pay Commission made recommendations in this case and that they were accepted by the Secretary of State and the intention was to implement them, and that in those circumstances they carry with them a particular force in terms of the purposive interpretation.
You accept that?
The regulations, yeah. So turning to those recommendations, can I invite you please to take up Appendix 2A. And if your bundle has MS numbers, we're turning please to MS 761.
Mine doesn't.
In which case it will be page 211.
Thank you.
So this is the first report of the Low Pay Commission. In it they make recommendations. The specific ones we're going to focus on are first at page 233 of the bundle, or MS 783, where the recommendations are set out. And turning the page to 784, you'll find recommendations 11 and 12. So focusing on 11 for the moment, it says the actual working time definition should define what constitutes working time for the purposes of the national minimum wage. So they say have a definition of what working time is, please. And then they say the national minimum wage should also apply to all working time when a worker is required by the employer to be at the place of work and available for work, even if no work is available for certain periods. So, two things to draw from that. The first is that the plain intention of the Low Pay Commission is to expand the circumstances in which someone will be entitled to the national minimum wage. So you should have a definition of what work is, and of course that will always count. But in addition, we want to draw in to the circumstances in which you're entitled to the national minimum wage, availability cases, where you're required by the employer to be at a place of work and available for work, even if no work is available for certain periods. So that will also count as time work. So you'll see that this would be on its face an example where you were doing nothing specific, and yet your mere availability was to be treated as being enough. The second thing we want you just to bear in mind is this is the first indication of what we've called the sequential approach. So the starting point is you have a definition of what working time is, and then it is also to apply specifically to availability in certain circumstances. But carved out of the cases in which availability is enough, we see at paragraph 12, for hours when workers are paid to sleep, whatever that means, on the work premises, workers and employers should agree their allowance as they do now, but workers should be entitled to the national minimum wage for all times when they are awake and required to be available for work. So what that seems to say is availability is enough unless you are paid to sleep, in which case, whilst you're asleep, you're not available, or not to be treated as available, and thus, in turn, not to be treated as performing time work.
Is there any explanation of what paid to sleep means?
Yes,
No,
quite
not so far as I'm aware.
it's a slightly ambivalent phrase, paid to sleep. I mean, clearly, however, paragraph 12 contemplates that when you are asleep, you're not necessarily going to receive payment for it.
No, absolutely. It anticipates what you're going to get as an allowance, although, as I said, they don't go on then the legislation to require an allowance.
Well, I'm not even sure that it does anticipate that you're going to receive an allowance. You're entitled to the national minimum wage when you're awake and required to be available for work. But that rather implies that when you're asleep, and by definition not available for work, you're not entitled.
Yes, so that's why
either
it says...
to the national minimum wage or to an allowance. And what these regulations contemplate is that there should be agreement between the worker and the employer about this.
Oh, I agree. So the allowance is the thing that is agreed. That's why I put it in those terms. For hours when workers are paid to sleep on the work premises, workers and employers should agree their allowance.
I see.
As they do now. So the intention seems to be, if you are awake and required to be available for work, then that entitles you to the national minimum wage. But if you're paid to sleep, whatever that means, they expect that to be dealt with by an allowance agreed between the employer. So a couple of things arise. This is talking about a carve out from availability. So the starting point is all time work counts. In addition, availability will count, but availability will not count if, as they put it there, you are paid to sleep. Now, what we'll see when we come to the other Low Pay Commission recommendations is the terms in which they identify what they had in mind tend to wander about from report to report. It isn't not always using the same language, and it isn't always clear that what they have in mind has been captured by the regulations. But what we will come to see is that there's an attempt to capture this distinction in the 1999 regulations. I'm going to take you there next, but just before we do, these specific recommendations are expanded upon later in the same report, paragraphs 4.33 and 4.34, and you'll find those at MS 832, which is page 282 of this appendix.
So which page again, please?
So it's MS 832 or page 282.
Okay.
So at 433, that's the first part of it, the recommendation that actual working time, as it's put there, should, the actual working time definition should define what constitutes working time for the purposes of the national minimum wage and the extension to availability. And they say this definition has the advantage of covering agreed downtime hours when workers are on site but unable to work, e.g. because of machine breakdowns or lack of materials. It includes all agreed overtime hours, including call-out hours for emergencies, but does not include standby or on-call periods away from the employer's workplace or agreed rest periods. And that does shine some light on what it is that at least the Low Pay Commission had in mind. Can I just make the point now, and I think I've already warned you that this may become repetitious to a degree. If one looks at what they have in mind there is someone who classically has other work that they might do, work on the machine, can't do it because the machine is broken down, but is available to do it once it becomes available. So their job is not being available to work should a task arise. They're precluded from performing their ordinary job and are therefore only available to do it. And that's, as we'll see, the first indication that what they don't have in mind is the special sort of case which this case is, which is where your job is being present to respond to occasionally frequently arising tasks. It's on call in the more traditional sense. At 4.34, they say certain workers, such as those who are required to be on call and sleep in their employer's premises, e.g. in the residential homes or youth hostels, need special treatment, and then they go on to set out the carve-out. Now, I will say later, somewhat pedantically, that we don't fall within those precise corners of the commentary at 4.34, but that ultimately...
Sorry, why don't you fall within that?
Well, because she's not on call, as the tribunal determined, and she's not sleeping on her employer's premises. She's sleeping in the private dwelling of two vulnerable adults.
Is that a material distinction? Why is that a material distinction?
Well, there's a reason why I said it will come across as pedantic. we don't fall within that, how it's been defined specifically here, but I'm not ultimately going to press that as being a distinction of materiality which is going to matter to your decision.
I mean, it seems they're clearly recognising there are these special cases of people, particularly residential homes, who have to sleep on. And at the moment, I can't quite see how that, if we start distinguishing you and that, we're getting into very sophisticated distinctions.
Well, what we're going to, no, so where we draw the distinction is to say, and what I suppose the key criticism we make of the Respondent's case is that when these recommendations are looked at and subsequent commentary is looked at, there's an assumption that somehow what are described as sleepovers or sleep-in cases are all the same in some material way, that they're an effectively homogenous group. There may be some variation, but they all fall to be treated in the same way. And our point is that's not true. There are some cases in which you will have other facts you can rely on which would persuade a tribunal that you're doing actual work, as my learned friend puts it, within Regulation 3 or Regulation 30, and there's some where you cannot, that you could only ever say that you're available for work, so you will only ever get the national minimum wage if you can bring yourself within the extension which is anticipated here. We say we don't have to do that.
The LPC reports which suggest that you have to go through that very sophisticated exercise.
Yeah.
I mean, one would expect them to have said, well, and of course there are these other categories who you can only determine on a factual basis, but do they say that?
No, what they do say later in, I think, the second report is that the fourth report, that there are a range of different factual circumstances which might arise, or words to that effect. But what it seems to be clear to us they are doing is they're saying, starting point is it work? If it's not work, are you available for work? If you are available for work, are you one of those people who are, as they put it here, paid to sleep, in which case, I'm sorry, we're prepared to extend the definition of work to include what I would call mere availability, but it's not extended so far that it will encompass you in circumstances in which you sleep. So as we'll see, B&A says you can both sleep and work for the purposes of Regulation 3. So what it ultimately boils down to is this, that so far as the legislation is concerned, you can sleep and still be working. You can be merely available and still be working, but you can't be merely available and sleeping and still be working. In other words, if both those boxes get ticked.
I mean, at the moment we're trying to understand what the LPC are saying, and it might be helpful to deal with that, because you say that whatever they're saying here has been varied by what they say later. Is that right?
Yeah, I think, so let me be clear what we say they say and what they don't say. What they say is there should be a definition of work. They say, in addition to the definition of what they call actual working time, the availability of the national minimum wage should be specifically extended to cover people who are merely available for work. And then following that sequential approach, that extension should not cover people who are paid to sleep. So what don't they say? What they don't deal with, we say, is people who are provided with facilities for sleep, permitted to sleep, and do so, but who would otherwise fall within the definition of performing actual work. So that's not what they have in mind.
They're contemplating residential home workers who have to be present overnight, aren't they, so that they can be on call?
Well, not always. So we say there's a difference between our case, where there's a specific tribunal finding that this is someone who is not on call, and sets of circumstances where you may genuinely just be on call. So I identified one of those earlier. If you think about a residential home, who knows, might have 50 residents in it. So I say, right, Mr. Edge, you're on tonight. So you are the person principally responsible for making sure that if anything happens, which involves the safety, care or welfare of the people in our residential home, that's on you. That responsibility does not vanish just because you've laid down and closed your eyes. You're the person who must sort all that out. It's not anticipated that anything will necessarily arise, so by all means go to your bed. But also, Mr. Davison, we want you there too. And what you're going to do is you're going to sleep in your bed, and if Mr. Edge concludes that you're required, then he will call on you. but you don't have any responsibility for identifying whether or not tasks have arisen. It's not your principal responsibility to ensure the safety, care and welfare of the people in the residential home. So in those circumstances, it seems to us, you might be more accurately described, Mr. Davison would be more accurately described as being on call. That's not Mr. Edge's position. He has a responsibility which is persisting throughout the night.
Even though he's asleep?
Even though he's asleep. So he can't, what he can't do is say, I know I am principally responsible for ensuring the safety and welfare of these people, but I'm also being told I can sleep, so I'm just going to go to sleep now, and I cease at that moment to hold that responsibility. That wouldn't be sufficient in our case for Mencap to meet its statutory responsibilities, and it wouldn't be the essence of what he's being asked to do. He's permitted to sleep, but he's the person who is there to make sure that if anything does go wrong, it gets dealt with. He's the one who has the qualifications, he's the one who has the obligation. And that makes him different to the Mr. Davison situation.
You said it's contemplating the sort of case where there may be those two persons, one with the primary responsibility for deciding whether or not intervention is required, and another person who has not got that primary responsibility, but who may be called upon by the first person.
Yes, certainly the authorities, as we'll see, contemplate that distinction. So far as the LPC is concerned, the way I get there is to say this, that what is clear beyond doubt when you read their recommendations is that the carve-out at recommendation 12, what they say at 4.34, is a subset of availability cases.
Well, could we just look at that? Because 4.34 begins certain workers, such as those who are required to be on call. So the certain workers is a larger class than those on call.
Yes.
And then it goes on, so it seems to me it's not ultimately clear. We may have to look at later recommendations as to whether the carve-out was only for availability. But it goes on, for hours when workers are paid to sleep. Is one way of interpreting that as when workers are expected by the employer to sleep?
That's certainly, I mean, I can't speak for what they have in mind because I genuinely don't know. That may be what they have in mind.
Well, it's paid to sleep on the premises.
Yeah.
I think to get the full flavour of what is... So that seems to me to indicate that they are required to sleep on the premises.
It does, and when we look at the regulations, which I keep teasing you with, but we're really only seconds away, you'll see that language of requirement is used.
But what about the youth hostel worker? I mean, the youth hostel, I assume there'd normally be possibly just a couple looking after the youth hostel and they have to sleep there. And obviously if an emergency arises during the night, they're expected to deal with it. And it may well be that an emergency arises 6 times in 16 months. But, I mean, how do they fit into this?
Well, I'm going to give you the traditional lawyer's answer and say it depends. That's our case.
Can't do. I mean, there's got to be some sort of standard rule for youth hospital people looking after youth.
Well, let me put it this way. I don't know enough about the youth
having to go
hospitals.
to the employment tribunal to work out what the answer is.
I think the answer is that if on proper analysis of the facts, and there's no suggestion, as I understand it, that the Low Pay Commission had paid any particular attention to these facts, the youth hostel as an organisation, the Youth Hostel Association as an organisation had some regulatory responsibility for ensuring that there was someone present, and they identify someone who is present. You're not then paying them to sleep, you're paying them to be present and to carry out those duties, but you're permitting them to sleep. That would be the difference.
I think it is very important to have the full rubric, paid to sleep on the premises.
Paid to sleep on the premises.
You're not being paid to sleep, you're being paid to be present in the premises.
So I think what this has in mind, and we think it's clearer when we look at the regulations, is that they are talking about a subset of availability. What they have in mind is people who are, the employer wants them there as a deployable resource. That's perhaps just to coin my own phrase. That's not the same as the claimant in this case. She's not there as a resource to be deployed. She is a deployed resource. She is the person whose job it is to be there.
Yes, so the distinction is between being available in the sense that you can be summoned and being on call, in which case you are required to respond to the call. If you're merely available, that seems to suggest that you can decline to make yourself available, whereas if you're on call, you don't have that option.
Yes, I mean, it becomes, so I say, what the Low Pay Commission then does is wander about a bit in the way in which it then subsequently deals with matters. I think my learned friend and I are agreed that the subsequent Low Pay Commission reports are interesting to the extent that they might be thought to throw some light on what the Low Pay Commission had in mind at this point, but these are the recommendations that are made before the implementation of the regulations. So I don't want to delay that any further, but
Right, well,
may I take you to the
on to that then.
So the 1999 regs are in the first authorities bundle. And we're looking at tab 2 and at MS page 36.
So which page again, please?
It starts at 34. I'm going to be taking you to 36, sorry.
36. Thank you.
Sorry, I'm getting the get on from my junior in terms of my allocated time, so I'll try and deal with this expeditiously. So, because you'll need to understand this for the purposes of everyone's submissions, if one looks at page 36, do you see there that there's a regulation 3, which is the definition of time work, which is one of the forms of work that might be available to be done. And what it says is work that's paid for under a worker's contract by reference to the time for which a worker works and is not salaried hours. For present purposes, 3A will do us. So what it's effectively saying is, if you're paid by reference to time, it's time work. That's great. What it doesn't tell you is what work is. It just tells you that if you're paid for it by reference to time, that will be time work.
Are these categories actually overlapping, or are they exclusive?
On the face of it, they're exclusive. So you'll see that time work is defined as something which is not salaried hours work. And we can see that unmeasured work, which is at regulation 6, unmeasured work means any other work that is not time work, salaried hours work, or output work. So they do seem to be mutually exclusive categories. As we'll see when we come to Walton, that doesn't necessarily mean that an employer always and invariably has to opt for one or other of these approaches. So that you could say to someone doing the job that the claimant was doing in this case, I'm going to treat this as time work, or you could say what I'm going to do is enter into an average hours agreement with you and reward you by reference to the tasks we think you're going to have to perform, and that would turn it into unmeasured work. So the same arrangement may be susceptible to different analyses, but it will depend on what's actually agreed.
Thank you.
So that's, as it were, the first part of the LPC recommendation. Please have a definition of time work, which they've done, but without a definition of work. And then we need to turn to MS 41, which is regulation 15. And here's where, for present purposes, it starts to get interesting. So regulation 15.1, in addition to time when a worker is working. So just pausing there, it's an expansion beyond the category where a worker is working. So you'll see, as we say, the sequential approach respected here at 15. The first question is, are you working? If you're not working, then in addition, time work includes time when a worker is available at or near a place of work other than his home for the purpose of doing time work and is required to be available for such work, except that in relation to a worker who by arrangement sleeps at or near a place of work, time during the hours he is permitted to sleep shall only be treated as being time work when the worker is awake for the purposes of working. So I need obviously to unpack that for you, because there's a lot happening in this bit of drafting.
Yes.
So just breaking it down into stages. The first thing is, regulation 15 is anticipating a prior question. is this a case in which a worker has been working and therefore performing time work? If not, we'll consider whether they are a worker who is available at or near a place of work, but then an exception, that can't be his home, for the purpose of doing time work, and is required to be available for such work. So you've got to be at your place of work or near it. The reason for you being there has to be for the purpose of doing time work, and you have to be required to be available for that work. So far so good. That's the expansion to cover what I've described as mere availability. I mean, it's best, I have to say, with all due respect to the draftsman, in the most complicated possible way, but that seems to be what they're trying to do, to implement the LPC's recommendation, to extend time work to include availability. Can I just ask you to note, while we're there, that so far, if you're going to extend to include availability for work, it includes the phrase "for the purpose of doing time work." So it's available for that purpose. We say that doesn't mean actually doing time work, because if it did, you'd fall within the time work definition. And the reason why I raise that is because we go on to see what it then says in relation to sleeping. Here's the carve-out. It begins with the words "except that," so it's clear that it's an exception. Except that in relation to a worker who by arrangement sleeps at or near a place of work, time during the hours he is permitted to sleep shall only be treated as being time work when the worker is awake for the purpose of working. So if there's an arrangement that they should sleep and permission that they should sleep, they're only treated as doing time work if they're awake for the purpose of working. So it doesn't specifically mirror the language of the Low Pay Commission, but I think everyone accepts it's intended to try and implement its idea that you carve out of availability cases a certain subcategory which relates to being permitted to sleep at or near a place of work. So my lady Arden asked me earlier, where is it clear that one is talking about being carved out from availability? We say, well, here it is clear. It's saying also availability except that. So that's the explicit carve-out.
But if you're...
Sorry, after you, please.
If you're available and you're asleep, you don't get paid.
Correct. Well, if you're available and asleep and you're sleeping at or near a place of work and you're permitted to be, so you can't, it's not whether you actually sleep, it's whether you're permitted to sleep and or actually
sleep. Sorry.
I was simply going to ask you about the words "in relation to a worker who by arrangement sleeps at or near a place of work." Isn't this regulation saying this is a worker who is in the realms of availability?
Yes, absolutely. And
this is not a worker who is working.
Yes, I agree. And that seems to be the express purpose of 15.1, to expand the circumstances in which someone is effectively to be treated as doing time work, but subject to this
Doesn't it then cast all workers who by arrangement sleep at or near a place of work into the availability category?
No, that's my learning friend's case.
I thought that was almost what you said to me a moment ago, but you didn't mean to.
I hope not, because that really would be accepting my learning friend's case in every one of its...
So can you comment on that?
Yeah. So this is how we say it works. You start first at Regulation 3 and you ask, is someone actually working? That's the journey we did in our case. The tribunal said, let's look at all the relevant facts. You're not someone who's on call, you're someone who's actually working. So you meet the requirements of Regulation 30, full stop. No need to go anywhere near Regulation 15 because you fall within the definition. So what Regulation 15 says, well, if the answer to that question is a no, if you're someone who's merely available for work, well, we'll still include you, but we won't include you in circumstances where you're sleeping at or near a place of work where you're permitted to sleep, so that it's a carve out from availability. And without again wanting to jump too far forward, May I invite you to have a look very quickly at the 2015 regulations, which is the one which apply here, which is at tab 4. And at MS page 72, this is the modern, as it were, equivalent of Regulation 15. You'll see at 32.1 it says, time work includes hours when a worker is available and required to be available at or near a place of work for the purposes of working, unless the worker is at home. That's the home exception. 2, in paragraph 1, so this is dealing with availability cases, hours when a worker is, quote, available only includes hours when the worker is awake for the purposes of working, even if a worker by arrangement sleeps at or near a place of work and the employer provides suitable facilities for sleeping. So it's clearer in the 2015 regs that this is a carve out from availability being otherwise an extension to hours of time work.
So just going back to 30, time work is work in respect to which work is entitled under the contract to be paid by reference to time work. Remind me, what was he entitled to under the contract in this case?
Oh, sorry, in this case,
Yes.
what had been agreed was an allowance,
Yes.
but she was to be paid by a time rate for any hours of work she did.
Yes.
So the way in which that resolved itself in the employment tribunal is they say, okay, so the contract provides for a time work rate for work. And what you have done is misunderstood what is work. So because we have concluded that she's not merely on call but is working throughout the shift, because you have agreed that she should receive a time rate, that's what she gets.
So it's not determined by the contract, you say. I mean, my immediate reaction to that was it really depends on your contract. You start by looking to see what the contract entitles you to be paid for.
Well, I agree. There is a contractual underpinning in our case, and it is that the parties have in practice agreed that any period of what my learned friend would call actual work should be treated as remunerable by reference to an hourly rate. Where they disagreed is what counted as work for that purpose. So, having shown you Regulation 15.1, and again, without wanting to become duly repetitious, we say that the natural reading of these regulations is one of sequence. Regulation 3 first. If you fall within that, all well and good. If you don't, you go to Regulation 15.1. If you are available, then if you're merely available for work, you're in the running for the national minimum wage unless you're knocked out because of either the home exception or the sleeping exception.
Well, you are knocked out, are you not? If you have to go to Regulation 15.
Yes, exactly. Now,
I mean, you've got to stop at Regulation 3 in order to succeed.
I agree. So my learned friend says, and I'll come to this in a moment, holistic interpretation, effectively read backwards. Start at Regulation 32 or Regulation 15. That's intended, as Lord Justice Underhill concluded below, to be a sort of comprehensive way of dealing with cases in which people sleep in or sleep over. And therefore, the appropriate purpose of interpretation is to knock out sleepers, not just from the availability category, but from Regulation 3 as well.
Is that a fair characterisation of how your opponent puts his case, or does he rather
I've never
say...
knowingly fair to opponents, but no doubt...
Does he rather say that one must look at the regulations as a whole and determine their meaning, and then you may apply them sequentially if that's what the regulations require?
Well, Lord, that was to be my very point. So you anticipate what we have to say on that. I doubt, but I'm going to be largely dealing with this, particularly given what time it is now in reply. We don't really dissent from the general principles of statutory interpretation, which are set out in my learned friend's submission. But what we say is even looking at it holistically, even looking at it as a whole, the natural interpretation of what is happening here is that you apply a sequential approach because that's the structure of the regulations. It's the best way to make sense of it.
Yes, but it's sequential only in the sense that you say you stop at Regulation 3. If you go on to the further regulations, then you lose.
Yeah.
Hmm.
If this is an availability case, this is why I started by saying the issue is essentially working or available for work.
Yeah.
Now, I had intended to take you in some detail through the second report, and with your permission, I'm not going to do that now, but I'll postpone it to reply,
Right.
because I want to take you through the regulations. So we have I hope there's a short stop at the 2000 amendment regulations. So they're the next tab along at MS 49. And you'll see at Regulation 6, it redrafts Regulation 15. I'll leave it, my lady and my lords, to you to decide whether it gets any clearer. But what it says is, Regulation 15, subject to paragraph 1A, time work includes time when a worker is available at or near a place of work for the purposes of doing time work, and is required to be available for such work, except where the worker's home is at or near the place of work, and the time the worker is entitled, the time the worker is entitled to spend at home. So pausing there, same we say sequential approach. First, is it time work? If it's not, it's to be treated as included availability at or near a place of work, unless the home exception applies. That's one sub A and B. Then a new subsection 1A, in relation to a worker who by arrangement sleeps at or near a place of work and is provided with suitable facilities for sleeping, time during the hours he is permitted to use those facilities for the purpose of sleeping shall only be treated as being time work when the worker is awake for the purpose of working. Now, interestingly, the way that appeared elsewhere in the regulations. If it appeared, for instance, in Regulation 3, that might rather make my learned friend's point for him. But in fact, what we see is when you look at new Regulation 15, subsection 1, 1A is qualifying explicitly the circumstances in which availability will count. So it's subject to paragraph 1A, time work includes time when a worker is available at or near a place of work. And then 1A says, availability doesn't count in circumstances where you're provided with suitable facilities for sleeping, which has arisen for the first time in this amendment, time during the hours you're permitted to sleep and do sleep, only to be treated as being time work when you're awake for the purpose of working. That phrase, for the purpose of working, again, we say can't logically mean and are actually working, because you would inevitably fall within Regulation 3 if that were true. So it doesn't have that in mind. It's a reformulation, but it's the same general pattern. Definition, extension to include availability, carve out from availability of certain circumstances in which sleeping is involved.
Do we know why the amendment was made?
No. There
must have been some reason, because someone must have...
Well, the insertion of provision of facilities for sleeping is important, isn't it? So you would have certainty in the situation.
Yeah, one would hope so. It's not, there was the second, this comes hard on the heels of the second LPC report, but doesn't seem to deal with the issues that the second LPC report had in mind. And this provision of facilities doesn't seem to be
And it's
specific.
not a response to a particular decision, is it, of the EAT? Or?
It doesn't appear to be, because the...
I mean,
in
the
effect,
explanation notes just say it was about increasing the minimum wage, so it doesn't help at all.
I mean, it's odd because it comes so quickly. I mean, the regulations, the previous regulations are only 1999. 2000,
Yes, but normally there'd be some explanation as why they were doing it. You say there's none.
Well, I'm not sort of saying there is one. I'm saying I haven't been able to discover what it is.
It's just to make sure that the legislation wasn't free from complication.
So, for the next quarter of an hour or so, 20 minutes, we're turning our attention to the courts, because they start to involve themselves now. And let me start by saying that we accept, of course, that nothing that I'm about to tell you about is in any sense binding on you, but I don't imagine you need to be told that. But the authorities do involve, we say, some hard thinking about the relevant issues, and some of them are actually quite easily misunderstood. They need to be looked at with a degree of care, and we say to some extent they have been misunderstood by the Court of Appeal in this case. They also provide some of the background to what happens in 2015, so they're useful for that purpose. So there are 3 Court of Appeal authorities. I'm going to take you incredibly briefly to 2 EAT authorities, and then into the 2015 regs, and then on in the last 10 minutes or so to the Court of Appeal decision below. So can I take you first to the BNA nursing case, which is in the first volume of authorities, tab 6, MS page 84. So this is a case which was concerned with, if I recall correctly, the unamended 1999 regulations. It concerns a 24-hour booking service for emergency nursing staff. During the day, that was a service which was run from an office. During the night, calls were diverted to people working from home. They had to answer the phones within 4 rings or apologise, the agreed statement of facts says, but otherwise they could do what they wanted. They weren't answering calls, including sleeping. The tribunal reaches a rather odd decision. They decide, and we'll see this recorded at paragraph 8 of the Court of Appeal judgment, MS page 86, that the workers working from home at night are working for the whole of their shift. So on the face of it, that would also include any time they spent asleep, since they were sleeping during their shift, or could sleep during their shift. But if one looks at paragraph 7, what they also seem to have accepted, because the parties agreed it, is that so far as time spent sleeping was concerned, that fell within regulation 15.1 of the National Minimum Wage Regulations, 1999. So those two things are quite difficult to reconcile. They seem to be both making a finding under Regulation 3, but then also going on to consider the position under Regulation 15, and the Court of Appeal duly struggles to reconcile it. So let's see what they do. If one looks at paragraph 12, at page 87, they conclude that it was open to the tribunal to find that these were people who were working throughout their shift. And from our point of view, this is a good example of a court looking at a relatively low frequency, task frequency case or job, and making the point that the gaps between the performance of those particular tasks are not time where you're effectively only available for work, but it's all treated as working. So if one picks it up at D, no one would say that an employee sitting at the employer's premises during the day waiting for phone calls was only working in the sense of being entitled to be remunerated during the periods when he or she was actually on the phone. Exactly the same consideration seems to me to apply if the employer chooses to operate the very same service during the night time, not by bringing the employees into his office, which would no doubt impose substantial overhead costs on the employer and lead to significant difficulties of recruitment, but by diverting calls from the central switchboard to employees sitting waiting at home. It was indeed as a continuation of the daytime service that the employer presented the nighttime service to his employees and recruited them for that purpose. So here Lord Justice Buxton is saying, firstly, of course you're working in the gaps between the performance of specific tasks, and who he says would think otherwise, and that the tribunal is entitled to reach the conclusion that they did, that someone was working throughout the shift, even though he observes at paragraph 13 that during the nighttime shift, the tasks may become less frequent still. He says that is, quote, nothing to the point. So, in essence, the point is that where your job involves reacting to events that may or may not arise, and if they do, may do so infrequently, the time between the performance of those actions is not mere availability for work, it is work. So what then happens is that the BNA's counsel develops what one might call an early version of the argument that you're faced with from the respondents here. He says that in practice the tribunal's precluded by Regulation 15 from concluding that the workers were actually working in the times in between answering the calls. The argument, that argument is given very short shrift by the Court of Appeal at paragraph 14, and you'll see that what's said there by Lord Justice Buxton is this: Regulation 15 only arises in a case where a worker is not in fact working, but is on call waiting to work. In this case, as we have seen, the tribunal found as a fact that the workers were working throughout the period of their shift. Regulation 15 is therefore irrelevant to these facts. Moreover, even if that were not the case, it is my judgment impossible to construe out of Regulation 15 a rule applying to the whole of these regulations that oblige the tribunal to make a different finding in respect of a person's activities with regard to work just because they were being carried on at the person's place of residence. So it focused principally on the home exception. He then goes on at paragraph 17 to consider this oddity that Regulation 15 had been applied to the sleep issue in that case. So he says at 17, Regulation 15.1 relates to workers who are, in colloquial terms, on call. When a worker falls into that category, he has to be paid the minimum wage for his waiting hours unless he's on call at home. I respectfully agree with the very clear analysis of the EAT. Moving on, however, if the worker is permitted to sleep when on call, the hours during which he's permitted to sleep when he's not actually working do not count as the equivalent of time work. The Employment Tribunal held that these provisions apply in the present case, holding that, as we have seen, has not been challenged. I cannot conceal my profound doubt as to that conclusion. Regulation 15.1 is arranged as a single provision. The exception that it contains, introduced by the words "except that," is indeed an exception. That is, it presupposes that the case is otherwise covered by the principal rule of the regulation. The principal rule, as we've seen, is confined to cases where the worker is on call other than his home. So whereas in our case the workers are asleep at home, they're not covered by the exclusion because they are not in any event covered by the rule from which they appear to be excluded. So he takes what we've described as the sequential approach and says, first question is, are you working? The tribunal in this case has decided that they were. Only then do you move to Regulation 15 if you have decided that this is someone who is not working.
This is under the unamended regulation.
This is the unamended regulation.
I mean, I notice that I'm always interested in these things. I notice that this proceeding started with a notice dated March 2000 with an appellant appealing against an enforcement notice. This is on page MS 85, appealing against an enforcement notice served by the Inland Revenue. And the Inland Revenue might have been instrumental in getting an amendment to the regulations to try and clarify a point which probably hadn't occurred to anyone until it was raised in this case.
Yes, and we'll come to what happens in relation to that subsequently. I think it's pretty clear it's the unamended regulation because if you look at 86 and E, MS 86, it's making reference to time work not including time when they are asleep in accordance with Regulation 15.1.
Yeah, I mean, it clearly is because the Employment Tribunal was heard before the new regulation came into effect. So that's clearly what it was, but I was just suggesting that I'm looking for the reason for the amendment. It may have been the Revenue becoming aware that this was a point being taken.
Yes.
Lord Carmouth might have a point, mightn't he? Because the Inland Revenue were responsible for enforcement, and these things can actually go to criminal proceeding.
They can.
And so clarity is essential. So
I agree.
That might well be the explanation.
When we come to 2015 regulations, you'll see that it said explicitly in the explanatory memorandum that they have remade the regulations with a view to increasing the clarity, to make it clearer. Whether they have succeeded is a different.
But anyway, it does mean that this judgment, although one treats with great respect, is actually not directly in point for our purposes.
Can I just take...
Can I just clarify? You're short of time, so very, very quickly. The third line of paragraph 17, he has to pay the minimum wage for his waiting hours. Is that a slip? Should it be waking hours? Look, you're short of time.
Yeah.
Don't answer my question.
I think it genuinely is waiting hours.
You do.
Because I think
Right.
what he has in mind is on call. So it's the whole of the regulation 15 and not necessarily the specific
Very well.
sub carve-out. But
Thank you.
so far as this is an authority which is distinguished below in the Court of Appeal, And as far as I can tell, it's not suggested that BNA is wrong for present purposes, in contradistinction to the Scottbridge case, which we'll come to next. We'll come to the Court of Appeal decision below shortly, indeed very shortly. But it is said of this case by Lord Justice Underhill that this case, quotes, establishes the fact that a worker is entitled to go to sleep in the intervals between particular tasks. The fact that they're entitled to go to sleep in the intervals between particular tasks is not necessarily inconsistent with them actually working for the purposes of Regulation 3 during the entirety of the period. So even in this case, in the Court of Appeal below, they accept that for the purposes of Regulation 3, if you're within the initial definition of whether you're working or not, the fact that you're entitled to go to sleep between particular tasks doesn't have the effect of saying that you're not working.
Paragraph?
That is paragraph 57 of the decision. You'll find it in Appendix 1, internal page 20, MS 570.
MS number again, please?
570.
570, thank you. Right.
So on to Scottbridge, please, which is tab 9 in Authorities 1, MS 152. This is another low task frequency case. It's a night watchman who I've referred to erroneously in my submission as Mr. Scottbridge. It's Mr. Wright, not Mr. Scottbridge. He is someone who is permitted to sleep when he's not working, who is provided with a mattress for sleeping. The Court of Appeal observe at paragraph 3 at MS 153. They find that he had little or nothing to do from 6 p.m. until 11 p.m, and from midnight till 5 a.m. Again, that's paragraph 3 at 153. And quoting from paragraph 4 of the Court of Appeal's decision, was only required to be awake for the purposes of working for 4 hours a night in what was a 14-hour shift. The argument that was run by the employer in that case is substantially identical to the one run today. So you need to read Regulation 3, as it there was, along with Regulation 15.1. And if you do so, the conclusion would be that periods when you were allowed to sleep were not to count as time work. And you'll see that argument set out at paragraph 10 of the report. And that's roundly rejected by the Court of Session in a House at paragraph 11. They say, in our view, the argument for the appellants is not well founded. The terms on which the respondent was engaged in the employment of the appellants, which we've quoted earlier, make it clear that in return for remuneration at the rate of £210 per week, the respondent was required to attend at their premises between 5 p.m. and 7 a.m, 7 days per week as a night watchman. The work which was paid for under his contract by reference to the time for which he worked was, for the purposes of Regulation 3, his attendance as a night watchman for the whole of those hours. So this is working by being present. The fact that the activities of a night watchman were not spelt out in the letter is neither here nor there. More importantly, the fact that the respondent had little or nothing to do during certain hours when he was permitted to sleep does not take away from the fact that he was throughout in attendance as a night watchman, required at any time to answer the telephone or deal with alarms. The Employment Tribunal, in our view, confused their estimate of the hours during which the respondent was generally active with an overall consideration of what was required of him as a night watchman at any time. Thus, we do not accept as conclusive the decision of the Employment Tribunal as to the period which was relevant for the purposes of the national minimum wage. On the facts before it, the whole 14 hours fell to be required to be regarded as time work for the purposes of the regulations. They explicitly follow a sequential analysis. They do that, we can see from paragraph 13, agreeing with what Lord Justice Buxton said in BNA. The Scottbridge case, we say, is not materially different to our case. The frequency with which he performed tasks may be somewhat higher, but this is a case in which he was provided with facilities for sleeping, tasks were infrequent, and he was paid for being there, being the night watchman and taking on those responsibilities. Just as he was night watchman throughout the night, whether or not he was dealing with a particular task, our client was a carer throughout the night, whether or not she was dealing with a particular task. The Court of Appeal below distinguished, or sought to distinguish, Scottbridge there isn't really a ground, we say, for material distinction, and it's noteworthy that the respondents before you simply argue that it's wrongly decided. So the last of the Court of Appeal cases, Court of Appeal level cases, which is relevant, is the Walton case. That's at tab 10, MS 155 of the First Authorities bundle. And the first, and frankly, not simply most significant, but we say determinative point for the significance of this case is this is not a time work case or a salaried work case at all. This is a case about what I referred to earlier as being unmeasured work. That's defined, as we saw when I read it to you a few moments ago, at Regulation 6 of the 1999 regulations, the following terms. In these regulations, unmeasured work means any other work that is not time work, salaried hours work, or output work, including in particular work in respect of which there are not specified hours. The worker is required to work when needed or when work is available. What the regulations then go on to do at Regulations 27 and 29 is to deal with how you work out how many hours of unmeasured hours work someone has done. And I'm going to simplify somewhat. The way in which it deals with it is to say it's the number of hours actually worked in the pay reference period, that's Regulation 27, unless there's what's called a daily average agreement, in which case it's the number of hours agreed unless the employer cannot show that that average is a realistic average. So it's open to the employer to sit down with the worker and say, let's agree how many hours you will get paid for. We'll set it out in a daily average agreement. Providing that's a realistic average, that is what they get. They get it if they work fewer hours than that. They get it if they work more hours than that. They get the hours that they have agreed in a daily average agreement. There is no equivalent to Regulation 15, which applies in unmeasured work cases. There's no deeming availability to work as counting as unmeasured work. The facts of Walton have some similarity to our own case. It's a care sector case. It's a carer in the home of a person cared for. In her case, she was there for 72 hours straight and wanted every hour counted and maintained, or is maintained on her behalf, that she was doing time work throughout. The tribunal, we can see at paragraph 34 of the Court of Appeal's decision, is reported as having decided as fact that she was not doing time work. So that's paragraph 32 of the decision. In the present case, the tribunal decided that Miss Walton was not paid by reference to the time for which she worked. There was an evidential basis for that decision, and it would not be right for this court to reject the finding. So this is not a time work case. So far as 34 is concerned, the tribunal also found, and this is upheld, that there was a daily average agreement in place. So that's how the person was to be remunerated as unmeasured work, hours determined by a daily average agreement. No equivalent of Regulation 15 applies. Nothing we say in Walton says that the sequential approach taken in time work cases, B&A and in Scottbridge, is wrong, and indeed nothing in this decision purports to say that B&A or Scottbridge were wrong. What is said about them is that they are properly distinguished. So coming to Milady Arden's decision, paragraph 38 of page 165, you'll see that what's said is that those authorities are distinguishable as time work cases. And coming back to paragraph 34, the final paragraph of Lord Justice Aldous' decision, it said that those authorities are not analogous. So we're not really anywhere near the facts of this case. Of significance, we say, is that paragraph 40, Lady Arden says this, there is, as I see it, a clear distinction in the 1999 regulations between working and being available for work. See, for example, regulations 3 and 15. However, the antithesis is not drawn in the context of unmeasured work. So it's significant, but not for the Walton case, because it is not a time or salaried hours work case. But what's also said is that that is a question of fact, whether or not someone is available or actually working, and we agree. That's our principal submission. It's a question of fact. It's not determined by mere analysis of the regulations, and it requires, as a question of fact, all relevant materials taken into account. What is said in relation to Walton below by Justice Underhill, and we'll come to this, is that firstly, it's significant that Walton is a case which actually considers, albeit they have no direct relevance, the LPC first report recommendations in relation to the home exception and the sleeping exception. And we'll see that what Lord Justice Underhill says is that you can deduce, it seems, from Lord Justice's silence on the point, and this is necessarily implicit in what Lady Arden had to say, that their view would be that if you are working 72 hours, you're not treated for those full 72 hours as performing what would amount to time work in a different context. In relation to, should we say, two things. Firstly, at the risk of breaking the world repetition record, this is not a time work or salaried hours work case at all. And we agree that it would ultimately be a question of fact, and facts may differ from one case to the other. And we simply don't, we say, know enough about the particular facts of this case to draw any conclusion from it, and if you did, it would effectively be overturned. So those are the three big cases, as it were, the more authoritative cases. Into the soil, which has been created by those cases, or from that soil, grow a series of EAT decisions. I took you earlier to the passage in my submission where I identify the factors that they have identified as relevant. Equally helpful to you, although I don't now have the time to take you through it point by point, is the EAT's decision in this case, which provides a fuller and, to my mind, better summary of the various factors which have been considered. But let me focus on just 2 points which are of significance in this case. The first arises out of Borough Down, which is an authority that gets specifically overruled by the Court of Appeal below. That's in Authorities 1, tab 7, at MS page 93. And that's a case about a sleep-in carer in a care home. And her title was Night Sleeper. The claimant was permitted to sleep subject to securing the safety of the premises. They received a basic payment for being there, plus a payment for each hour actually worked. So you'll see the immediate parallel to the circumstances of this case. The EAT determines, and we'll see this at paragraphs 13 to 15 of the decision, that they should adopt a sequential analysis, which they take from the B&A decision. They also find, at paragraph 24, that Scottbridge is indistinguishable from the circumstances in Borough Down, and that as a result, Regulation 15 is never engaged. That's the result of the sequential analysis. So if one picks it up at 98, top of 98, having identified Scottbridge, then President Elias says this: like the claimant in that case, even during the time when he was permitted to be asleep, he was still required to deal with anything untoward that might arise in the course of his shift. It was not a case where he was deemed to be at work, although only available to work. So neither Regulation 15.1 nor Regulation 15.1a, so we're dealing with the 2000 regs, were ever engaged. In our judgment, the tribunal was right to say that Scottbridge was indistinguishable and should be followed. I then mention one more authority in passing, which is the South Manchester Abbeyfield Society Limited and Hopkins case, which is in the second authorities bundle at tab 21, MS 273, and I'll give you that for your note. But at paragraph 38 at MS 283, what is identified is, quotes, a clear dichotomy between those cases where an employee is working merely by being present at an employer's premises, e.g. a night watchman, whether or not provided with sleeping accommodation, and those where the employee is provided with sleeping accommodation and is simply on call. So we say what emerges from the EAT authorities, which have grown from the Court of Appeal to Court of Accession authorities, is you take a sequential approach. You ask first if they are working. There are factors which point to them being at work by being present, to use the Hopkins formulation, one of which is the factor that was, we say, critical here, and which we discussed earlier in the course of my submissions, which is the existence of a regulatory requirement to have someone present. But what is the approach which is significantly not taken is to say, well, when you read Regulation 3 with Regulation 15, what that leads to ineluctably is a conclusion that anyone who is at work, provided with facilities for sleeping and permitted to sleep, is not to be treated as working for the purposes of Regulation 3 in circumstances in which they are asleep. So we're nearly there. What's the impact of all that? Well, my learned friend says, well, fair enough, but the LPC recommendations are not put in any of these cases. That's true. The closest one gets is that in the Hopkins case, which I referred to a moment ago, Walton is cited, and of course Walton makes reference to the LPC recommendations. But I couldn't possibly characterise the AT authorities as being ones in which there are a careful run through the LPC recommendations. They, on the whole, do not appear at all. But we say that wouldn't make any difference, because the sequential approach is not only what we think the LPC is recommending, but is the clear best interpretation of the regulations themselves in any event. What happens then is that these decisions become very well known and much discussed, and employers are put in a position where they have to react to them. So these are cases which are coming out over the course of a decade. And there are various different things that they could do, one of which is to, as it were, tear up their existing arrangements and put into place Walton-style arrangements, where they have average hours agreements, and they can, at that point, protect themselves against the range of fears and dangers which are identified in my learned friend's submissions, suddenly being told later that people were at work when they had assumed that they were not. They could agree a number of hours, which, if realistic, would then be treated as capping their obligation. And there's a range of other things they could do. They could seek advice, they could rely upon the AT's guidance insofar as that helped them, seek an HMRC clearance, go to the High Court and seek a declaration. There's a wide range of different things that they could do, but their option was not simply sat passively waiting to see how matters would develop. So we now get to 2015 regulations and events immediately before it. 2 points I need to mention in passing. The first is this. In 2014, the LPC is receiving evidence for the preparation of its 2015 report. The government puts in interim and final evidence. It's the interim evidence which is relevant for present purposes. You'll find that in the Respondent's additional documents at page 217 or at MS 2062. And the relevant passage is at MS 2133 or page 288 of the document.
2,133, did you say?
2,133.
Thank you.
So the government's evidence was the government believes that workers should be paid the minimum wage if what they are doing amounts to work under the contract that they have with their employer. If the worker is working, which is a question of fact for the tribunal to determine, then the minimum wage is payable, and that is the end of the matter. Provisions about whether or not a worker is asleep only come into play in circumstances where the worker is available to work but not actually working. In cases where the workers must be present at their place of work, they are in effect working even if their employer allows them to sleep rather than carry out other activities, the workers should get paid the national minimum wage. So there's no doubt that what the government has in mind is the authorities that I've just taken you to. That's an accurate summary of what they say. It's expressed, however, to be the government's view, and bear in mind that what it's doing is giving evidence to a body that has a power to make recommendations as to what the law should be in this area. So we'd say it's not in form or indeed in substance, merely an update on what position the EAT had got itself to. It involves a specific endorsement of a sequential approach, and a specific endorsement of the idea that the question whether someone is working or merely available for work is a question of fact. Guidance is issued, and I won't take you to it specifically because it is to much the same effect, in February 2015 by what was then BIS, though I accept that when one looks at the guidance, that is not preceded by any indication that it's the government's view. It's, as one might expect, guidance which reflects the existing state of authority.
Sorry, whose guidance is this?
This is BIS's guidance, and for your note, you'll find that at Appendix 2C, at page 877 or MS 1427. And in particular, the relevant passage you'll find at 1457, which is page 907, if you don't have the MS number.
90.
It's page 907 or MS 1457. The LPC then report in March 2015. They summarise the government's evidence accurately. They go on to say, we believe that there would be a benefit in making these points clear. They have in mind, it would appear that there should be some...
Which page are we on now?
Sorry, so I've now moved to the LPC Commission report of March 2015. That's in Appendix 2C at MS 1488.
And hard copy.
That's page 938. And in particular, what you're looking
Sorry, where were you reading from?
So you're looking for page 1186. It's a genuinely enormous report.
Yes, I'm just trying to find what you were referring to.
And at MS 1736 and at paragraph 5.98. So you'll see there's an account of sleepovers, as they call, which begins at 5.96. They summarise the government's view at 5.98. And in the final sentence, they say, in the light of the recent court decisions, we believe there would be a benefit in the official guidance making these points clear. So what's unclear, as a matter of historical fact, is whether when this paragraph was drafted, they were aware of the BIS guidance of 2015, or whether they were expecting some still further guidance. But there wasn't any. What there was is a set of regulations redrafted for clarity. And you'll find those at Authorities Bundle 1, Tab 4, at MS 54. And we've seen these provisions before. If one turns to MS 72, you'll see chapter heading time work. The meaning of time work set out at paragraph 30.
I'm afraid your time is up, Mr. Jones.
Is it?
It is.
I thought it was 1 o'clock I was finishing, sorry.
Well, according to this, it's 12:50.
Ah, then my time is up,
Your time is up, I'm afraid. Thank you.
in which case I'll sit down.
Yeah. Mr. Edge? Thank you very much indeed. Right, Mr. Glynn.
May it please your lordships, your ladyship, I want to join your lordship in paying tribute to not only my learned friends, Miss Stone and Mr. Parkin, but also their instructing solicitors, Morrison and Forster, who have acted pro bono in this matter.
Oh, good.
And,
well, I'm glad that you drew that to my attention. I'm sorry that I was remiss in failing to acknowledge them.
my lord, not only have they shown the highest standard of the bar in terms of the case which I have had to meet, I say that with some hesitation, but also More than that, there was an application as a result of Mr. and Mrs. Rampersad not being represented for them to seek to adjourn this hearing. And by their speedy intervention, that application didn't have to be dealt with.
Thank you.
My Lords, my Lady, I have a short period of time of just under 70 minutes, thanks to Mr. Jones. But what I seek to do is to show that the Shannon appeal raises two issues. First, what hours count for the purposes of the national minimum wage for salaried hours work under the 99 regulations? What hours count for the purposes of the national minimum wage for salaried hours work under the 99 regulations? Secondly, as part of that submission, the way in which the Regulation 16 provisions, and you've heard a lot about the Regulation 15 provisions that apply to time work, but similar provisions, the Regulation 16 provisions, apply to salaried hours work, how that provision operates, covering both the at-home and sleep-in paragraphs. And Mr. Shannon potentially engages a much wider class of employees, namely the at-home employees. This was, my Lord, Mr. Shannon's sole work for the Respondents. When he began in 1993, he was being paid just over £7 per night, plus his accommodation. When he was dismissed in 2013, his pay was about £12.85 after he paid for his accommodation per night. The outcome that we seek in this appeal is that all the hours that Mr. Shannon was in his flat between 10 p.m. and 7 a.m., when Mr. Shannon was required to be in his flat and required to respond, count for the purposes of the national minimum wage. All the hours between 10 p.m. and 7 a.m. count because Mr. Shannon was required to be in his flat and required to respond. We respectfully submit that there are three reasons why the Supreme Court should so hold. Firstly, our first submission is that the express meaning of the regulations, as they apply to salaried hours work, determine that that should be the case, and Regulation 16 is simply irrelevant. That, we say, should determine this appeal, and one need go no further. However, if you're against me, we also submit further and alternatively two further submissions, and here we overlap with Tomlinson-Blake. I adopt Mr. Jones's submissions insofar as they go. I seek not to repeat them, but I go further than he has done. Our second submission is that Regulation 15, Regulation 16 are not prisms through which to assess whether a person is working. They are not the test. They are additional deeming provisions. Our third submission, following on from that second submission, is the question whether a person is working comes first. It is always a multifactorial inquiry. The question whether Mr. Shannon was working is approached through a multifactorial test. We say, where, as here, the trinity of three matters are present, then Mr. Shannon was working, and the employment tribunal should have been driven to the conclusion that he was working. And the trinity of those three factors, which should be taken conjunctively, are firstly, the requirement to be present in a limited location. Secondly, the requirement to respond from that limited location. And thirdly, where those two requirements, the requirement to be present and the requirement to respond, are present because they are discharging a regulatory obligation of the employer, then we say the employment tribunal, and on those facts, one should be driven to conclude that there was work. We accept that this is an evaluative question of mixed fact and law. We accept that this is a perversity challenge to the tribunal's decision.
So it's the only possible conclusion.
On the facts of this case, my Lord, yes. And so I perhaps I take a position which adopts clear line clarity. When those three factors are together, as I showed that they were in Mr. Shannon's case, then that was work. As simple as that. But my first submission requires a construction of the regulations. And I know they're just a few minutes, but I am under time pressure. And I'd like to use those few minutes to make a start on the regulations, although I won't finish them. Can I invite you, please, to take up Authorities Bundle 1? And all my page references will be to the memory stick, the MS number, and not to any other number. And if your lordships or your ladyship doesn't have that number, if you just ask me and I'll provide it.
It's only in the appendices that we don't. In the main documents we do.
I'm grateful, my lord, thank you. So if one can take up, please, the main authorities bundle and go to tab 2, page 37. I think it was my Lord Kitchen who said that work is defined by context and the context of the regulations, and that's where we need to go first in the salaried hours work case. And under Regulation 4.1, the regulations of salaried hours means work that is done under a contract to do salaried hours work. So that's under a contract to do salaried hours work. That is defined by 4 conditions. And in these regulations, there is an overlap between Condition 3 and Condition 4. The first condition is, if we look, the first 3 conditions are under paragraph 2. A contract to do salaried hours work is a contract under which a worker, Condition 1, is entitled to be paid for an ascertainable number of hours in a year, referred to in this regulation as the basic hours. The basic hours is the currency of salaried hours work. It's a basket of hours which are ascertainable for a year. Secondly, under regulation, paragraph 2b, is entitled in respect of hours that consist of or include the basic hours to be paid an annual salary, and little one, this is the one that applies in Mr. Shannon's case, by equal weekly instalments of wages. And it goes on at the end, regardless of the number of hours in respect of which the worker is entitled to the annual salary that are actually worked by him, if any, in any particular week or month. And C has in respect of those hours no entitlement to any payment other than his annual salary, or has no such entitlement other than an entitlement to a performance-based bonus.
It's a standard salary payment
Exactly, my
scheme.
lord, precisely. For my part, 2C is largely replicated by paragraph 6, which is the 4th condition, insofar as it adds anything. Paragraph 6. The final point before lunch, my lords, is paragraph 3. A salaried hours work, paragraph 3, a salaried hours contract, or a contract to do salaried hours work, satisfies the condition in paragraph 2, does so whether or not all the basic hours are working hours.
That rather echoes 2b, or the last 2 lines
Yes.
of 2b. Yeah.
My lord, but it's more general. 2b is restricted to the fact that hours may vary within a year. What 3a is wider than that. 3a is saying whether or not all the basic hours are working hours. It has a wider application, we say, with respect, my lord.
Mm-hmm. Thank you.
My lords, if I pause there, I'll start with Regulation 14 after lunch.
We'll sit again at 2 o'clock. Thank you.